During closing arguments, can the attorneys talk about the law that the judge is going to give to the jury once we're done with our closing arguments? Would you like to learn the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. At the very end of the case, when we give closing remarks, we have an opportunity to ask the jury to give us a verdict in our favor. What we're doing during closing remarks is summarizing the testimony and the evidence that's been presented. And now we're trying to show to the jury how those facts are in our favor. And now what we're trying to do also is try and get in a little bit of the law. Now remember, I should tell you that in New York, the attorneys are not permitted to discuss the law with the jury during closing remarks. That's the judge's function. But before we begin closing remarks, the attorneys will have had a private conference with the judge known as a charge conference. And during this conference, the judge is going to tell us exactly what law he's going to be instructing the jury on. This way we know exactly what points have to be made. And now we can sometimes allude to the type of law that the judge is going to be talking about. Sometimes we can take a phrase here or there from the law that the judge is going to discuss. But we cannot give them definitions. For example, if it's a negligence case where somebody tripped and fell, or it's a car accident case, we cannot give the jury a definition of what negligence is and say, ladies and gentlemen, the judge is going to tell you in just a few moments that negligence is carelessness. And now I'll get an objection from my adversary, and the judge will say, objection sustained, meaning I can't talk about the law in detail. But I can gloss over it and I can bring up certain phrases that they are likely going to hear when I'm done, when my adversary is done, and now the judge goes ahead and explains to the jury what the law is in this particular case. Now, why is that important? It's important because of something known as recency. If I go ahead and start telling them what to watch out for, what to look for, when the judge tells them in a few minutes about what he's going to talk about, now in their minds, when they hear it from the judge, they connect what I said with what the judge is instructing them. But guess what? The defense attorney likes to do the same exact thing. So now they have competing interests saying, hey, the plaintiff's lawyer said that, the defense lawyer said that, and now in their minds they give different weight to different things that are said. And so the whole idea, the whole goal, the strategy is to try and preempt, try and get this information out first, because we know that the judge is going to be talking about it, and we'd like the jury to recognize and remember that we were the ones who said it first. So why is this important? Why do you need to know about this? You need to know about this because it gives you a different perspective as you're deciding whether or not to bring a lawsuit on your own. You know, in all likelihood, you've got questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're contemplating bringing a lawsuit and you've got legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.